Welcome to our podcast, Michelle and Stacey, All Things Small Business.
We hope you enjoy this episode and please visit our website, michelleandstacey.com.au.
That's MICHELLEANDSTACEY.com.au. We would love to hear from you.
Welcome to Michelle and Stacey talking all things small business. Thanks for joining us for episode 7 of Selling Your Business series. We are lucky to have today with us Andrew Henshaw, who's the Managing Director of Velocity Legal. Today we'll be talking about why it's important to get the right lawyer to help you get the most out of your business sale. Welcome, Andrew.
So, Andrew, my first question to you would be, why is it so important to have a robust sale contract?
Yeah, excellent question. And thanks for having me on the program. Look, there's a lot of reasons. Sometimes you have clients or people that come to you and say, oh, look, you know, we don't really need anything too special. We've known each other for a long time, as in the buyer and the seller. But, you know, the accountant or the advisors have just told me repeatedly to get something. So we'll put something in place. I guess like for the very simple or the sort of the smaller deals, it's still important. The deal might be less complicated, but if something goes wrong, like you're kind of sort of stuffed without having something in writing.
Yeah, that's right. So
because then it just becomes an argument over what the terms were, what's the price, what was supposed to be sold, what was supposed to be promised. You know, without anything formal contract, it's sort of okay. Maybe you're trawling through emails to try to work that out, but it's sort of you're in a very weak position.
So would you suggest, or I mean, this is how I'd probably do it, is try and get before we even talk to you, if it's the accountant that they're talking to or some other business advisor, really they need a clear vision of what they want to sell and how much they really want to, you know, for it, and things like that. So what do you think you need to involve in that vision to make sure that we're kind of clear? So by the time it gets to someone like yourself, you're going, yep, I can put that into a good, robust kind of contract. What are the types of things that you encourage?
Look, I think you've got to start with the commercial terms. Don't worry about tax first. Don't worry about legals. Just focus on the commercial terms. Is this a good exit strategy if you're selling? How long am I going to have to work for? What's the price? What am I willing to guarantee, promise? Just work on the commerciality of the deal first, because if the commerciality doesn't hold up, or the legal, the tax is kind of irrelevant. So I think the starting point should always be the commerciality and sort of having an in principle agreement, whether that's a handshake arrangement or something slightly more formal like a heads of agreement or letter of intent. Once you've sort of reached, I guess, sort of a base level on that commerciality, it's then looking at the structure, looking at the legals, looking at the tax. What are you selling? What's your entity? Are you a company? Are you a trust? Are you selling shares? Are you selling a business? What are the terms? And I think the most important thing for business owners selling is how much money they're going to get left with at the end of all this as a net figure.
Just before you go on, can you just explain a little bit more detail about the difference between a heads of agreement, say, and the actual contract, and what's binding and what's not?
Yeah, so there's a number of different terms for, I guess, the agreements that come before the actual sale. The terms are heads of agreement. It might be letter of intent. It might be term sheets or something else. The gist of those documents, and they all can vary slightly, but the gist of those documents is it will set out who's the buyer, who's the seller, what's being sold, what's the price, what's the time frame to sell, what's included, and bells and whistles and things that is particular to the deal. And then, very importantly, it will usually have sort of a window, so to say that we'll work together over the next 2-3 months to conclude a deal. And during that time, there's usually exclusivity. So I sign this, it means I'm not going to start talking to other people about selling. And importantly for the business owner, there's usually confidentiality provisions. So if the deal doesn't go ahead, and if I've already forked over, important information about my business, my customer lists, things like that, then I have some protection to stop that potential purchaser where the deal's fallen over going to go and use all that information anyway.
Yeah.
So those are the main things. So it's a bit of a playbook for how things should go from a commercial perspective. And it has that exclusivity and confidentiality part to it.
What about if you haven't really decided on the price yet? Like they're still negotiating. Like, would you get involved in that negotiation? Like traditionally have, like in the deals that you've done, and I'm sure you've done quite a few,
Yes.
how involved do you get in the price negotiation?
Usually not a lot involved in it, to be honest. It's usually the client's already said, by the time I'm involved, usually the client has said, okay, I've lined up this deal. Here's the overarching, like broad brush. Now we need to refine it. And what does it look like? And how do we achieve it? And all that stuff. Sometimes I would be involved in the price, but it would more be from a, how is it going to be paid type perspective rather than what's the actual number. So it might be that, what's the term of payment, or maybe we're talking about conditional payments or earnouts. And it might vary there, but that's usually where I would get involved.
And in terms of like a process, is there a particular process that you would work your way through with a client that's selling a business?
In terms of process, lawyer's favorite answer is it depends. My background is as a tax lawyer. So the times that I'm involved in business sales or equity sales is usually, well, sort of as close as possible to the start of the transaction. Sort of that's where my involvement would be heaviest, and it would sort of peter out as the process goes along. With a commercial lawyer, so that's someone who's drafting the documents, doing the negotiations, they're sort of more the other way, that they won't have that much involvement typically at the start, and then their involvement will get heavier and heavier with the contract drafting and negotiations and all the way through to settlement of that deal. So the reason why the involvement of a tax lawyer is heaviest up front is because that's where you've got the potential. Once you're committed to a particular pathway, particularly in a contract, then there's very little room to move. There might be some room to move, and there might be some issues, but by the time you've agreed on, okay, we're going to do X, Y, Z, and this is how it's going to work and all this sort of stuff, then a tax lawyer can tell you what the outcome of that is going to be, but they can't change that outcome.
No, that's right.
Why it's important to have a tax lawyer involved is early on, because there might be a number of different ways of achieving a sale, and they might all have different tax consequences or considerations or risks. So I could give you one example. One that becomes complicated is where you've got a client that's got a business run through a discretionary trust, and they want to sell shares because someone wants to buy a company. So on one side, we've got a business owner running a business through a discretionary trust. And on the other side, the person purchasing it says, I want to come a company because it's going to be 50-50 ownership for the first few years, or 80-20, or some other variety. And it doesn't really work with a discretionary trust. So you've got to put your thinking cap on and work out, okay, how do we get to where we need to go from a structuring perspective? So to answer the question, in terms of process, it really depends on I think as much as I can sum it up as a process is usually I would say broad brush what you're trying to achieve, and then work out, are there different ways of achieving it? What's going to be best? And then the client would, in conjunction with the lawyer or tax lawyer, they would sort of propose, okay, we've come up with this broad deal, and here's how we see it working from a more granular perspective.
But for specifically small businesses though, because what you're talking about is that they're actually buying the entity as opposed to just saying buying goodwill and other bits and pieces that go with it. So I don't know, but from your experience with the smaller sales, would it, generally speaking, it would be more like a goodwill kind of a sale as opposed to an entity sale?
Yeah, I guess it depends what's your threshold for small business versus non-small business. I would say the $1 million purchase mark is the dividing line. Anything less than $1 million is usually a business sale. And I think sort of between maybe 1 and 3 million, it's sort of probably sort of like 50-50, or it could go either way. Once it gets above 3 million, it seems to be very heavily in favor of share sales.
Yes.
But not always. There's differences. There's key differences between the two. And that's why it's important to sit down with a accountant, tax lawyer, and work out what the actual after dollar figure and the result is going to be from one versus the other.
Yeah.
Yeah.
Okay.
In your experience, have you seen clients where how do I put this? They're thinking about selling and they know in the future that they'll sell, but they haven't really done any work around getting ready for that. And then they get approached by someone and, the deal just, what's being offered just sounds like too good to be true, or they're so happy with it. Like, well, ultimately I want to sell, but I haven't thought about it. Yeah. Okay. Yeah. Look, yeah, let's keep talking. Let's do this now. And they basically end up proceeding to sell, but they haven't really done a lot of like legwork, beforehand, because it's sort of come out of the blue a little bit. And then there's obviously the, complete opposite end of the scale where someone's, spent 2 or 3 years getting themselves their business, in ducks in a row for a sale and getting all organized. Have you seen where that's gone better versus,
Yeah.
not as well? Like, yeah, like what are some, I guess, war stories or some,
Yes.
stories that, obviously not mentioning any names, but just, yeah, is there anything in particular that you can comment from that perspective?
Absolutely. I think where you're running a business and you get approached to sell out of the blue, you might not have all your ducks in a row. And by ducks in a row, I can give some examples: employment agreements, contractor agreements. What are you selling? Do you actually own it? Do you have evidence that you own it? What do your key customer contracts look like? Are they in writing? Do you have leases? Do you have other issues? Do you have some unresolved litigation that's going on? Any one of these things I'll back up. I guess the first point is, if you're having to run around and do all that stuff, it can be very stressful because you're doing all this other stuff at the same time. You might be going through this process for the first time as well. So you're running around doing all this stuff, getting stressed about all this. The first point is it will often be used by a purchaser as a way to reduce the price down and say, oh, we've uncovered all these issues. I know we said, this, but, now that we've done our financial and legal due diligence, this is the new deal, essentially.
Mm.
And for a purchaser or a vendor, so someone selling at that point, it's sort of, yes, they could work away from it, but a lot of times they don't, because they've already they've put a lot of energy into this, etc. And they're sort of just, and it could be a bit of a slippery slope where the purchaser and their advisors, they start making more and more demands. So, and it could lead to the whole deal falling over as well. So if you do have everything ready to go, your ducks in a row, so to speak, it just takes that stress out of it. And I've had war stories and situations where it is that situation where someone's been approached out of the blue. They've had to do all that stuff and then the deal's fallen over. The clients are generally not that unhappy about that situation. They sort of generally see the silver lining and say, oh, well, at least we've kind of seen what the process looks like. And at least we're kind of ready now if, when a sale happens in the future as well. So it's sort of not what to do. It's a learning process, I guess, as well.
Yeah. And what about, can you just take us through what is allowable, say, for strengths of trade and things like that?
Yeah.
Because someone might sell and they might be still quite young and they've, as you said, they've just been approached and great opportunity, they've taken it. But then what are they going to do after that? Because they might not necessarily be ready to retire. And if they've only worked in that kind of industry all their life, they might want to do things. So maybe just give us a bit of
So I think taking a step back, purchasers would generally want the vendor around for some degree of time. It's very rare to see a business sale, or at least in my experience, where the purchaser wants absolutely nothing to do with the vendor in any way, shape, or form. And it's usually because, they want a sort of a continuity. They want employees to stay. They want customers to be reassured that, it's sort of business as usual. And that owner or former owner may have a lot of, know-how, etc. It's very rare to sort of want to just buy a business and say, I want absolutely nothing to do with the person that's selling it to me. It's possible, but it's very rare. You then sort of get looking at, well, what level of involvement do I want this, the business owner to have? Do I want them around for 6 months, a year, 2, 3 years? Do I want them sort of to have a stake in the business still? A lot of deals I see, they don't buy 100%. They buy typically 70 or 80%. And I believe that there's some magic to that in terms of financiers, and they want to see, oh, well, this person's still involved and things like that. So a lot of times I see it's sort of like a 70 or 80% sale, not 100% sale, and then sort of rights to buy out the remaining bit over a few years. Another way I see it is that sometimes some of the purchase price varies, and it might vary based on the profitability of the business in the future. So purchaser might say, well, all right, I'll pay you whatever amount, but I'm only really willing to pay that if the business is as good as you say it is. And what's the best way of seeing that? Well, let's see the future financial performance of it. If all the customers leave afterwards and so forth, it tanks, then I'm not going to pay you the amount you want. And that the business owner selling might say, well, yeah, that's no problem. It's a great business and I'm willing to sort of take that variability. And it might be sort of a payment over 2, 3, perhaps even 4 years. And that's typically called an earnout. It's based on the sort of the future financial performance of the business.
But what about, if you're the seller, how do you safeguard that? Because the person who buy it might be absolutely hopeless at running the business, and how do you safeguard yourself if you're the seller in that instance?
It's a great point. If you're selling 100% and you're not a director anymore and you have limited involvement, it's very difficult. Because you've passed this business over. We can put things in contractually to try to deal with some of it, but at the end of the day, the person purchasing the business, if they run it down, it's sort of difficult. What I was going to say is, in all these situations, you want to have restraints of trade against the person selling. So I guess it's kind of obvious, but if the business owner still has a seat at the table or some equity or something like that, then of course there's going to be restraints, and they're going to be very strongly enforced as well. So anytime the business owner still has, I guess, a stake in the business, or if there's an earnout or things like that, then restraints are going to be pretty easy to enforce. If it's more the case that it's the business owner's been paid out everything already and now they have no involvement, not even as an employee or contractor, that's when you start to look at, okay, how far can these restraints cover? There's what's in the contract and there's what a court would enforce. And there's a difference between the two. Typically what you'd see is sort of a minimum of sort of 3 years post-sale, post getting out completely.
Yeah.
It would often be anything to do with that industry. Typically, you can the courts are much more willing to enforce restraints of trade against business owners. There's all stuff in the media over the last year about restraints of trade in sort of lower paid industries for employees, like hairdressers and childcare workers and things like that. And there's actually a government proposal to ban some of those restraints of trade. But when you're talking about a business owner who's often getting a big slice of money from selling their business, courts are saying, well, why would anyone pay that if you could compete with them the next day? So for that reason, they typically take a sort of a much longer view. The longest I've seen 8 years, believe it or not. Now, would it be enforceable? I don't know. They got a lot of money from the sale. Would you want to risk it as the person that's walked off, with this, sale and so forth? Would you want to risk litigation? Litigation's expensive and uncertain. So typically not. Yeah.
And these restraints of trade, are they typically more enforceable in a service industry versus a product-based industry, or similar?
I think it's similar. There'll be differences in terms of sort of geographic limit. So usually with a restraint, it would mention, okay, there's different types of restraints. Firstly, there's restraints against poaching employees and clients, and they're typically pretty easy to enforce. As in, okay, I've sold this business to someone, and then I turn around and start trying to get the employees and trying to contact the customers and things like that. You can see why that's pretty easy to enforce.
But what about if you say, oh, well, I haven't approached anyone. My employee's not happy with you and they've resigned and they've approached me for another job.
Yeah.
Is there a difference between that or not?
Yeah. And that's the non-compete situation where the restraint might say, okay, I've sold an accounting business and I've decided to start up my own separate accounting business. And then it just so happens that some of those customers have gone to approach me because they want to use me, let's say. And that non-compete will say that, well, you cannot provide those services for this amount of time within these amount of kilometers of Melbourne or Sydney or some other geographic area. And it can be hard to point to those ones where you've sort of gone out and solicited people, particularly in a digital age where, all you need to do is sort of say, oh, I've got a new website and here's my LinkedIn profile and a few other bits and pieces. And people will find out, particularly if it's a smaller industry, they will find you. So that's the point of a non-compete, that it says, well, even if they do find you, you cannot
Take them. Yeah. Yeah.
It can be often, I guess, one of the things with looking at those is in those business sales where there is the person who's staying on, there sometimes is a discussion about what they're going to get paid going forward. Well, there always is a discussion about what they're going to get paid going forward, but there's a sort of a bit of a tension that when the business owner sells, what they get is a capital sum generally from selling. They can have 50% CGT discount. They could have small business concessions. In general, that amount that they get is concessionally taxed, and it could be as low as 0. And even worst case scenario, it's 23.5%, assuming the 50% discount. So it's a pretty good rate of tax for capital. In contrast, for a wage, a salary, some sort of fee, potentially looking at the top marginal tax rate, or at least one of the other rates, we sort of say let's say between 40% and 47%. So it's far worse. So as a seller, there's a sort of a natural tendency to sort of want to, let's say I could bump up the purchase price, but I agree to work for 50 grand a year for the next 3 years. You can see why there's sort of a natural tendency to sort of load that into the capital amount rather than the ongoing salary. There's a limit to how far that could go, but that's a common point that I see.
Yeah. Yeah. Good. Is there anything else that you think from your experience that you'd like to kind of just give us some good little pearlers or something? Yeah.
Yeah, I think you got to start with understanding, like, what are you selling firstly? Is it goodwill? Is it plant and equipment? Is it trading stock? Has it been written down? So it could be written down for tax purposes to 0. We could be saying, oh, I've got a business that's worth $4 million. But okay, what's that $4 million comprised of? Like, what gives it that value? Is it because there's a bunch of machinery? And if it is machinery, has that machinery been written off for tax purposes? So what do I have? And then what am I going to sell? Am I going to sell the assets? Am I going to sell equity? If I'm going to sell equity, am I selling 100% or something less? A lot of the times there is drivers to sell equity rather than the business, particularly above the $1 million mark. So I think that's really important to do that exercise up front and do it as close as possible to a sort of a letter of offer, that type of arrangements. Usually comes after the letter of offer, sometimes before.
So just talking about that, the difference between like to say with goodwill versus plant and equipment. So how much proof do you need what the plant and equipment is worth? Because that's so subjective, right? So obviously for the seller, it's much better to have it as goodwill as opposed to plant and equipment, and the opposite for the purchaser.
Yes.
How do you put in the contract that, that it's kind of can you put it in, does it have to be very specific or a little bit vague?
Yeah. So if you're talking about a business sale, of course, you're selling all the assets of the business. You're selling goodwill, plant and equipment, stock, et cetera, et cetera. And for tax purposes, you're not just selling one asset. You're not selling a business. You're selling a whole bunch of assets which have different tax characteristics. And there is, as you said, there's this tension here because the purchaser might want all of that to go not to goodwill. Generally, it's the worst situation for purchasers having the value to goodwill. They might want it to other assets which they can get depreciation for, like plant and equipment. So sometimes you'll agree between you and the purchaser as in what the breakdown is. And if you do agree, you would usually put that in the contract. You'd usually apportion the contract. We say this much is for this is for this is for this, etc. Sometimes you just can't agree though, or you don't want to agree. In that case, what happens is the contract's silent on the breakdown. And then it's sort of left for each party to sort of work it out on their own. And it's an interesting situation because each party has to do their own tax and, they're not really privy to what the other party's doing anyway. So they sort of have to take their own position and they might not be the same. Now, The ATO generally doesn't like when things are not the same, but it could be argued, maybe both the positions could be arguably correct. I guess what I'd say is if the parties have come up with something and stated it that's just completely on another planet, it's probably higher risk still. But if it's not completely off the planet, that would be accepted as the breakdown. If it's a situation where they haven't agreed, then I think you need some sort of basis to back up what you're saying is the breakdown between the two. If we're talking really significant amounts of vehicles or machinery or things like that, then getting sort of specialist reports on, okay, what's the value of that thing? I think that's kind of probably the only way where you're talking. I'd say more than $250,000 worth of plant and equipment. If it's over that, then you really need to sort of be pretty diligent with it. In terms of other things to consider, I think it's just getting really clear on what the structure and what the actual deal is and what are the specifics of it, particularly when you're not selling everything up front or the seller's staying on or there's earnouts or things like that. You really need to be just really clear up front what that means from a tax perspective, because it's sort of like a choose your own adventure book, but you only really get to choose that adventure at the very start. And once you commit down a path, it becomes very hard to change that.
Yes.
Even if you haven't signed the contract, you can lose a lot of goodwill with and I've seen this situation where the seller's selling and they didn't get the right advice up front, and then they sort of started down one journey, and then I said, hey, look, you're going to be so much better off doing it this other way. And they had to sort of go tail between their legs back to the purchaser and say, oh, look, I know I want to change it. And it's it's not a good look. And it doesn't put you in a position of strength either. Even if you can salvage it, it's still not a good look. So do it up front, do it as close to when you sort of get that inkling that there's a serious deal on the table.
Yeah.
Sometimes it could be worth planning these things years in advance as well. If you're talking about things like the small business CGT concessions, they have hard thresholds, like the $6 million threshold. And if you've got the benefit of planning and time, you may be able to plan for those things and make sure you actually do qualify. If you're just at the 11th hour calling up myself and saying, oh, I've already signed this contract, or I'm going to sign it next week, what can I do? And sort of, well, you can't really do anything. It's too late. So you've got to sort of plan a couple of years out as well.
Yeah. Yeah. Well, I mean, I always say when I'm approached by someone who wants to sell, I'd say get someone like yourself involved right up front, because, we can give them tax advice, but I mean, the beauty of having someone like yourself, you're a lawyer and understand and do tax as well. So,
yes.
We can't interpret the law the way you can. So I think it's really important to get someone like yourself involved right up front. Once you've got, as you said, a serious deal on the table, or, the intent is there that you want to go ahead.
Yeah. And then from there, it's about implementation. So, a commercial lawyer for that. But once you get the structure up right front and locked in, then that's sort of, you're going down the right pathway.
Yes, that's right.
Definitely. And I think that was really the purpose of having this discussion with you today, which we really appreciate your time in doing so, is that it is important to get the right lawyer at the right time. And I think the more you can speak to them about it along the journey, the better.
All right. Well, I think on that note, thank you very much again. We really appreciate it. And
yeah, no problem.
Both Stacey and I have used you and know you used your firm well. And, from my clients, they have had really glowing experiences with you. I just want to say that. So
thank you. Thank you. It's about like, you've got two different hats you've always got to wear. You've got to wear the technical and work out the legals of things and, what you can and can't do and come up with the solutions and all that. But then if you can't communicate that, the client doesn't understand, or then why would they have any confidence in you?
Yes, that's right. And you need someone who's not too much jargon and puts it in like layman's terms and things.
Yeah.
All right.
Fantastic.
Thanks very much, Andrew. See ya.
See ya.
Thanks.
Bye.
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 Thank you for listening to today's episode. We hope you found it informative and useful. We would like to clarify that this podcast is for educational purposes only. The conversations are of a general nature and do not qualify or constitute as financial or tax advice. The views and opinions expressed by the hosts and guests are their own and do not reflect any official stance. We make no guarantees about the accuracy, reliability, or completeness of the information presented and are not liable for any losses or damages arising from its use. We recommend you seek the advice of your own legal, financial, or other licensed professional before making any decisions based on the information provided in this podcast. We hope you enjoyed today's episode and tune in again soon to listen to further episodes.